Welcome to The Advocates. I'm Aaron Dean. Democrats are again launching a new attempt to pass the John R. Lewis Voting Rights Advancement Act. Democrats have repeatedly tried to restore the voting rights protection that was promised in the Voting Rights Act of 1965. A 2013 Supreme Court ruling effectively nullified a provision that forced states with a history of discriminatory voting practices to get federal approval to pass new voting laws or maps. Since then, 29 states have passed nearly 100 restrictive voting laws targeting voters of color. But does VRAA have a chance now? Well, the Advocate Channel's Tracy E. Gilchrist spoke with the president and general counsel of the Mexican American Legal Defense and Education Fund.
This year, Democrats in the House are giving lawmakers another chance to restore voting rights and protections with the John R. Lewis Voting Rights Advancement Act. The bill previously passed the House in 2021, but failed to pass in the Senate. It would restore protections of the 1965 Voting Rights Act that were severely undermined by a Supreme Court decision in 2013, Shelby versus Holder. Joining me now is Thomas A. Saenz, President and General Counsel for MALDEF, the Mexican American Legal Defense and Educational Fund. Thank you for being a part of the Advocate Channel.
Thank you.
Yeah, thanks for being here. Mr. Saenz, it's been 10 years since the Voting Rights Act was stripped of many powers. What trends have we seen over the past decade that target Black and Brown voters?
Well, we've seen a lot of changes in voting procedures, as you know, that have made it more difficult for folks to cast, in particular, an in-person ballot, as well as to vote remotely. These have included restrictions on who can assist in casting a ballot. They've included restrictions on how you may qualify and exercise the right to vote remotely. A lot of that obviously exacerbated by the pandemic and voting during the 2020 election in the midst of the pandemic. We've also seen structural changes, attempted at least, to change how you elect council members, for example, switches from district elections to at-large seats, for example. And finally, we've seen, particularly in this decade, lots of mischief attached to the redistricting process, in which state legislators and other line drawers at local level have attempted to take advantage of the fact that there is less vigorous Department of Justice oversight by drawing lines that probably in many cases would have been rejected under the provisions of the Voting Rights Act that were struck down, as you indicated, 10 years ago in the Shelby County case.
Great. Well, thank you very much for that information. And this bill restores protections in states with a history of voter discrimination, Alabama, Georgia, but have voter suppression tactics spread beyond those deep South states in the last decade?
Absolutely, which is why I'm very proud that the John Lewis Voting Rights Advancement Act also includes a supplementary coverage formula for pre-clearance, which is what was struck down 10 years ago, which required those states, as you've indicated, with histories of voter suppression to subject their electoral changes to a pre-clearance review. So they could not be implemented until the Department of Justice or a district court in Washington, D.C. approved them, having analyzed to determine if they have any discriminatory intent or undue discriminatory effects. But because it has extended beyond, we now have in this act a supplementary coverage formula that's come to be known as practice-based preclearance or known practices coverage that would apply more generally across the country, but it would focus specifically on changes that we've seen misused, abused in the past to suppress votes. So for example, if you want to switch from district elections to partially at large, or if you are a city looking to annex or de-annex large portions of neighboring areas or edges of your city, if you are, for example, engaged in redistricting in a context of significant demographic change where one particular minority group has grown substantially over the course of the decade prior to that redistricting. If you want to change ballot procedures with respect to translated materials, these and other changes would be subject to preclearance pretty much wherever they occur nationwide. The only exceptions would be for those jurisdictions that are overwhelmingly of one race alone.
Thank you so much for that. And you served as a civil rights attorney for 12 years, and the argument that Republicans are making against this bill is that it's unnecessary. They say it's just Democrats trying to swing elections to their favor. What do you say to that?
Well, I've been in this business for actually a quarter century, and this is a change. It's important to note that Voting Rights Act was subject to reauthorization over the years. The last time in 2006, and even the last time in 2006, there were bipartisan supermajorities in both the House and the Senate that supported reauthorization, and that included the provisions that were later struck down by the Supreme Court in the Shelby County case. So it is relatively new in the last decade or so that we have seen so much of a decrease in Republican support for the Voting Rights Act and its many important provisions. I think it's pretty clear the reason for that is that the Republican Party is afraid of the demographic change in this country and the party's lack of success in attracting significant votes from the communities that are growing, the communities of color that are growing. That is primarily the Latino community. And as you probably are aware, Latinos generally vote 60 to 65% for Democrats over Republican candidates. And that's not a matter that is set in stone, obviously. The Republican Party could change its platform, could change its issues to achieve a greater proportion of that vote. But I think it's pretty clear that Republican leadership is afraid of the growing Latino vote and would like to see it suppressed. And that's why we've seen this shift from overwhelming bipartisan support for the Voting Rights Act to this current highly partisanized opposition to the Voting Rights Advancement Act.
Thank you. And, Republicans would also say that the VRAA is outdated. Would you share why you think it's still vital?
Yeah, I think the notion that we no longer need protections on voting rights is simply false. We see every year changes made in how folks are allowed to vote, whose effects are clearly intended to be and often result in suppressing the votes of particular groups of people. That tends to be younger voters, as well as elderly voters, and voters of color. And that results in boosting the likely turnout in support of more conservative candidates. We've had very candid statements made on the record in some cases, sometimes inadvertently, by party leadership from the Republican side, indicating that they are interested in suppressing votes in order to enhance their chances of prevailing in elections.
President Biden is celebrating a big anniversary for the Americans with Disability Act and the Rehab Act. The ADA was passed in 1990 to protect people with disabilities from discrimination. The Rehab Act was passed in 1973. It prevents discrimination based on disability within the federal sector. Actress and disabilities rights activist Selma Blair gave credit to the late Judy Heumann for her contributions. Blair says that the fight for equality continues.
I'd had symptoms since the age of 7. It took a lifetime of self-advocacy to finally lead me to a diagnosis at age 46. After living most of my life in pain and self-doubt, it was the late, great Judy Heumann, without whom we would not be here today, who taught me my worth. In my own disability advocacy, I have realized that these historic pieces of legislation were vital steps towards fairness, but the push towards equity continues.
And the U.S. Postal Service is out with a new stamp honoring the late Supreme Court Justice Ruth Bader Ginsburg. The new stamp shows Ginsburg wearing her black judicial robe and her famous white beaded collar. Ginsburg died in 2020 at the age of 87 and was a leading liberal figure on the court for decades. She also was the first woman to take the bench in the court's history. Chief Justice John Roberts says that the honor couldn't have gone to a better public servant. Thanks so much for watching The Advocates. Download the app in the Apple or Google Play Store to stream us live, and you can subscribe to our YouTube channel. For The Advocate channel, I'm Aaron Dean.